Again, good morning, everyone. And to give his welcome remarks, I'd like to call now on our board member, the Honorable Jose Arnold Tan.
Sorry, mute pala. So good morning, Chair Ophel, Bing Pilar, Bieng Paeng, and of course to all our real estate practitioners participating in this third episode of the virtual RESA awareness program of PRBRES. And of course, good morning all those who are watching us on Facebook and YouTube. Since there is a growing concern on the illegal activities being perpetrated by unscrupulous developers, real estate brokers, and real estate salespersons, the board has invited a resource person from the Department of Human Settlement and Urban Development to enlighten us on their intensified campaign against such illegal activities. Let us also take this opportunity to collaborate, cooperate, support SUD in its campaign for the common good of all real estate service professionals. Back to you, BM Paeng.
Okay, thank you, BM Arnie. Napaka-special po ng araw na ito dahil pinaunlakan po ng ang PRBRES ng ang aming imbitasyon. I will not take much of his time. It's really an honor for the board and for all of us na pinaunlakan po tayo ng officer in charge of the Housing and Real Estate Development and Regulations Bureau under the Department of Human Settlement and Urban Development, none other than our dear Attorney Angelito F. Aguila. Take it away, Attorney.
Thank you very much. Good morning. Good morning to all. May I be allowed to share my presentation, please? Yeah, thank you. That's okay. Again, good morning to all of you, to all the board members of PRBRES. It's my pleasure, and I'm very happy that we are given this opportunity again to be part of this activity. It's been a long time since we came up with our rules on brokers registrations, salespersons registration, as well as on advertisements back in 2015 and 2016. And somehow with the change of administration and the enactment of the new Department of Human Settlements, we were not able to pursue this series of lectures on our lectures on brokers and salespersons, on our campaign against illegal practice of those unlicensed and unregistered salespersons and brokers. So again, this is a very good opportunity. We welcome this. Thank you very much for this chance. Okay. Let me start by introducing again our new department. A lot of people are still referring to the HLURB, sending us letters addressed to HLURB. Again, there is a new Department of Human Settlements and Urban Development created through the consolidation of the HLURB, the Housing and Land Use Regulatory Board, and the Housing and Urban Development Coordinating Council, or the HALCI, to become the new Department of Human Settlements. So it became the law was signed in Feb 14, 2019. We now have our IRR. We were supposed to be fully operational this 2020, but our transition was slowed down by the pandemic. But we're trying to catch up with our new mandates, consolidated mandates and fresh mandates. So there is now a Department of Human Settlements and Urban Development, to which the regulatory power of the HLURB was transferred. So our new mandate, combining that of HALCI and HLURB, the department is primarily the one responsible, the primary government entity for the management of housing, human settlement, urban development. That includes the real estate development and from the HLURB, we are now the primary and the sole and main planning, policy making, and regulatory body. So we are the sole regulatory when it comes to the regulations of real estate projects like subdivision projects, condominium projects, including the registration of licensed brokers and accredited salespersons engaged in project selling. Just to summarize, for those who may be wondering, what was the transition of all of you who have been familiar with the HLURB? These were the powers of the HLURB all transferred now to the new department. The regulation of subdivision and condominium projects and other similar real estate development projects, and the regulation and registration of licensed brokers and accredited salespersons engaged in project selling. I am emphasizing here, before we can regulate them, before they can engage in project selling, they should first be, of course, licensed brokers and accredited salespersons from or by the PRC and PRBRES before they can engage in project selling and before they can be registered with us. Okay, that's our main topic for today. And then also, the two other main functions of the HLURB, the regulation of homeowners and homeowners association, as well as the land use planning and monitoring functions when it comes to the CLUPs of the LGUs and their formulation of zoning ordinances, were likewise transferred to the new Department of Human Settlements. So now, a lot of issues now when it comes to when we regulate and when we require brokers and salespersons to still register with us, a lot of are complaining, why is it that they are already being regulated by the PRC, PRBRES, but at the same time, there's double regulation with the department now. So just to freshen up, maybe a lot of you are familiar with this. This was the case resolved by the Supreme Court upon enactment of the RESA law. It's a little bit, it's funny when RESA was being enacted, there were some groups questioning it, saying, why does the PRBRES have to regulate the brokers and salespersons engaged in project selling, where in fact they are being regulated by the HLURB then under PD 957. So what the Supreme Court said is that there is no conflict. All brokers, all salespersons engaged in real estate service must be licensed with respect to brokers and with respect to salespersons accredited by the PRC and PRBRES. They're the one regulating them. But there's no conflict when they have to engage in project selling, when they are selling house and lots in subdivision projects or condominium units. There is a separate requirement that they need to register also with the HLURB before, now with the Department of Human Settlements under PD 957. So there is no conflict, okay? So all brokers, all salespersons are regulated by the PRC and PRBRES, but when they have to engage in project selling, when they have to sell condominium units, when they have to sell house and lots in subdivision projects, which are regulated by the HLURB before and now by the department, they need to likewise register with the department now, previously with the HLURB. So this case settles that issue. Why are there two government agencies regulating brokers and salespersons? Okay, this is primarily the governing law and provisions under PD 957, which is the Subdivision and Condominium Buyers Protective Decree. It does not only prescribe standards and it does not only regulate the development of condominium projects and subdivision projects, it likewise regulates the practice of brokers and salespersons along with dealers, but there are not much dealers now. So the practice of brokers and salespersons engaged in project selling is likewise required under PD 957 to be similarly regulated or further regulated by the HLURB before, now the department. So we have section 11 of PD 957, which requires the registration of licensed brokers and already accredited salespersons. We do not register unlicensed brokers. We do not allow unaccredited salespersons to register with us and engage in project selling. First and foremost, they're under the primary regulatory authority of the PRBRES. So they have to be, and the PRC, they have to be licensed first and accredited first. So section 11 provides for the requirement of registration. It provides for the qualification and procedure and the schedule of annual renewal. So again, I will go once in a while in some details, although I am given a brief, just a brief time for this presentation. But one of our issues is that a lot, I understand a lot are not complaining, but expressing their concerns. Why is it that for PRC and PRBRES, the requirement under SLO is 3 years, the renewal of registration, or yeah, and then for us under PD 957, it's annually. We cannot change that. Is provided in the law. So for now, we have to settle that. In so far as the department is concerned, there's a requirement of annual renewal. That's in the law. In as much as we want to ease down the requirement, it's provided under the law. Okay, and then section 12 of the law, PD 957, provides for that such registration with us can be revoked, and there are grounds and there's a procedure for revocation, which I will briefly discuss later. So to implement these two provisions of PD 957, sometime in 2015, we've been going around giving lectures and disseminating this new issuance of the HLURB, then the 2014 revised implementing rules and regulations on dealers, brokers, and salespersons, which is Board Resolution 922, series of 2014. And a lot of you were familiar that when we were implementing this, we came up with a lot of memorandum circulars just to adjust the procedure, to accommodate, to expedite the procedure, to make it a lot easier for brokers and salespersons. Like we dispense with the requirement of notarization and some of the documentary submission. But I think we need to further enhance this, because I mean, lately we've been hearing the issues here would be some unregistered or unlicensed brokers and some unaccredited salespersons are still able to register with us. And then sometimes we require some documentary submissions which are not readily available. So this we need to further discuss and try to make our procedure. We need to discuss with the PRBRES. We need to consult brokers, and just to further make the procedure a lot easier and more convenient for real estate practitioners. Okay, just briefly, probably a lot of you are familiar with this already. There's a requirement of filing of application and renewal of registration with our regional offices, the requirement of documentary submissions. Okay, this is where we normally get some problem that some are not yet readily available, like the certificate of registration, the identification card, the official receipt or claim stub. So again, this is something we need to further polish and refine in order to facilitate the registration and renewal process. We require, again, the letter of engagement of salesperson from a registered broker, because we are all familiar that the salespersons must be supervised by a licensed broker, and at the same time, the limitation on how many salespersons can be handled by a singular broker. So we require this letter of engagement. And then, of course, there's a payment of registration fee. For brokers, 720 pesos, and salespersons, 288. And likewise, the requirement of posting of cash bond or security. For brokers, the amount is 5,000 for salespersons, 1,000, but you only need to pay the premium. Sometimes we also provide the cash bond, which is permanent and refundable in case the brokers or the salesperson would not want to would desire not to any more practice. They can have it refunded. That's for the cash bond. So otherwise, for the security, 5,000 for the brokers. You pay the premium for that. That's annually, and salespersons 1,000. You pay the premium for that. Okay, even if you are registered with us already, you have to comply with some of our norms and ethical conduct for real estate practitioners. And some violations may be a ground for suspension or revocation of registration, as well as forfeiture of the bond posted. Like if you violate any provisions of PD 957 or any of its IRR, if you make any material false statement in your application for registration and your renewal, if you commit any fraudulent act in connection with any sale or a plot or unit in any project, and in general, any unworthiness to engage in the practice of real estate service can be a ground for suspension and revocation of registration and the forfeiture of your bond. This is more serious. There are other offenses. Brokers or salespersons found selling without registration for, with the department, that's 10,000 per apprehension. If you were caught selling with expired registration, well, 5,000. And this is the one we are trying to prevent and trying to disseminate to all practitioners, brokers and salespersons. Please do not sell units, house and lots of projects which are not yet licensed. Otherwise, you might be charged also of selling without of units or house and lots in a project without license to sell. The penalty here is actually a bit hefty. 10,000 per saleable lot or unit. That is imposable on the developer, and our regional office might just decide to impose that also on brokers and salesperson on a per lot or a per unit basis. So that's a lot of penalty. Selling of lots or units in an unlicensed project. We also impose admin fines, like if it's your first offense, additional 5,000 pesos. If your second offense already, 10,000 pesos. Plus, we can revoke your registration, we can disqualify you, and we can recommend to the PRBRES the suspension or revocation of your licensure or accreditation. So those are the admin fines which we are imposing. Okay, but before we proceed to advertisement, I just went briefly with our rules on brokers and salespersons, but I would very much appreciate if we next time we'll give more time. We can discuss it in detail. So, but for now, I just have to go briefly on our rules on brokers and salespersons. Another set of rules which the HLURB before, now the department is implementing, is the rules on advertisements, which is very much tied with the practice of brokers and salespersons, because they do advertise. They do a lot of sending out of messages, posting on sending on emails, on Facebooks, on their online or advertising. So, and again at the start, let me emphasize that all forms of advertisement in whatever media are covered by our rules, because the law, even if it's an old law, PD 957 way back in 1977, it says that it covers all advertisement in any media. At that time, it only provided newspaper, radio, television, circulars, but it says in all other form of media. So now, how many years? 30, 50, almost 50 years after, we have online advertising. It is very much covered by our rules. A lot would get the impression that they are not covered because of monitoring and implementation issue. Understandably, it's difficult on our part to apprehend, and it gives the impression that they are not covered, but they are covered. And way back in 2015, we've been telling and advising licensed brokers and accredited salespersons, if you're aware of any of other unlicensed brokers and accredited salespersons selling advertising, please report that to us. Come up with a screenshot or proof of what they're doing, and we'll try as much as possible to enforce our rules, try to apprehend them. Our regional offices have their monitoring office or division, which can correspondingly impose these sanctions on unlicensed brokers, unaccredited salespersons, unregistered with us, and those advertising without prior approval, and those advertising of projects without license. Okay. In brief, the provision, Section 19 of advertisements, Section 19 advertisements of PD 957, it provides for what's the coverage of advertisements, how should the advertisement be, what is the liability of the owner and or developer, and what are the sanctions if you fail to comply in our rules with our rules on advertisements. So all those requirements under advertisements I will briefly discuss with you, and these are all embodied in our Board Resolution 921 series of 2014. So actually, these are twin issuances, 921 and 922, advertisements and brokers and salespersons and other real estate practitioners. So at that time, first issue they were raising is, what if we just want to announce that there will be a project like a soon to rise here condominium project, which is a mere announcement? Is that covered by our rules on advertisements? The governing principle is advertisements is intended for selling. If you are just announcing with no intention of selling yet, but just to make the prospective buyers be aware that there will be a good project later on, and probably they save up their money, that's just an announcement. That is not, there are restrictions, but in general, they are not covered by our rule on prior approval. The difference is, for announcements, like for example, on this site will rise a new condominium, on this site will be developed a new subdivision project. Only the owner or developer can make announcements. Brokers or salespersons cannot make announcement, because once they announce, what is the intention or purpose of brokers? To sell. So in general, well, brokers cannot make announcements. Salespersons cannot do that, only the owner or developer. And even without license to sell, owner or developer can make announcements just for the purpose of informing or notifying the public. There is no requirement that we approve your announcement material, provided it will not contain any statements indicating or suggesting marketing or selling. Like for example, if it's just announcement, but when you say, hurry, few units left, that's actually already selling. So there are prohibited statements in an announcement, statements that would amount to or suggest marketing or selling. In contrast, in an advertisement, aside from the owner or developer, broker or the salesperson may on their own make advertisements or advertise, provided first there is a prior approval that the project being advertised is already licensed. And when you advertise, there are mandatory statements and there are prohibited statements, which I will explain later. So that is to draw the distinction between what is an announcement, which would not require a prior approval from us, and an advertisement, which would in general require prior approval. Which means we have to approve your advertisement material. That is the meaning of prior approval. You submit the advertisement material, even if it's on media, even if it's online, brochures, flyers, they have to be approved before dissemination. Okay, what are the governing principle in our advertising rule? First, of course, that we're always saying there has to be truth in advertising, and in general, the advertisement, the material must reflect the real facts. The information presented there should be in a manner that will not tend to mislead or deceive the buying public. And there are material facts which should be indicated therein. Like for example, later on I will discuss this. What are these material facts? The locations, the developers, the license to sell number, they must be indicated there. And they should not include prohibited statement or information. Even in when you represent what would be the design and standards, amenities, the time of completion of your project, be it subdivision project, be it a condominium project, there are rules in our advertisement, in how you advertise them. First, representations on design and standards, amenities, and time of completion must strictly conform with the project approved plan or program. Remember, this is already licensed. When you say licensed already, you have submitted your work program, your design and standards, or project plans. So all your representations in your advertisement must conform with the approved plans and programs. Only amenities and facilities specified in the approved plans may be included or illustrated. If the project does not, for example, contain a swimming pool, you cannot include in the advertisement any, in words or in picture, a swimming pool. Otherwise, that becomes a warranty and the buyers can enforce that even if it's not included in the approved plan, because all representations in the advertisement are enforceable warranties whether or not included in the approved plan. So mag-ingat po tayo na wag po tayo maglalagay na meron sa condo, merong bars sa taas, may gym or what other amenities which are not included in the approved plans, because they become warranties and the buyers can force the developers to provide them. Otherwise, if the buyer would say that is tantamount to breach of warranty, they can demand rescission of the sale because they relied on that why they bought the unit or the house and lot. Okay, even failure to timely complete or deliver what is promised in the advertisement, what is represented, is considered a breach of warranty. So we are also saying time of completion must be stated there. And if you fail to deliver that, the buyer has the right, that is considered as a breach of warranty. The buyer has to demand rescission or some reparations for your breach of warranty. In fact, even the manner of payment, the financing scheme, when you illustrate that or disclose that in the advertisement, there is a set of rules. For example, no mode of payment scheme may be included unless fully disclosed. Hindi yung partial lang dinidisclose nyo, iba tinatago nyo sa installment payment. Suddenly, after 2 years, may magbaballoon payment, and then you will not disclose that. Once you disclose the financing scheme, disclose it in total. Okay? You have to disclose the source, availability, the other charges, interest rates, third-party financing. Interest rates stated in terms of annual percentage rate. The problem here is that a lot of buyers, they get the impression that it's cheap, the interest rate is very low, but actually what was stated in fine prints, it's on a per month basis, monthly basis. If you multiply it by 12, like for example, 3% times 12, that's 36, or is that right? Yes. Or 2%, 24% pala annually. So just to make it, for the buyers to have a full grasp of how much is the financing cost, the interest rate must be expressed in annual percentage rate, okay? And then whatever you represent in the advertisement must be embodied exactly what is provided in the sales document. So there should be no discrepancy in what is in the sales document and what is represented in the advertisement material. Even in the way you present the pictures and illustrations in your advertisement, there are rules. For example, you have to say This is an actual photograph. This is just an architect's perspective, an artist's illustration, or such other similar caption. If you are, if you kind of notice lately, what there are a lot of advertisement. They're saying creative visualizations, pinapaganda nila, but they can sometimes be deceptive. So you have to caption the pictures and illustrations, whether they are actual photos or just perspective, drawings only, illustrations only. The only difference for cluster development, this is a very important requirement. Like for example, if you have 2 or 3 towers of condominium towers, even if you are just selling the first tower 1, you have to show their towers 2 and 3, even if it's just shadow image. Kasi we have encountered a lot of buyers complaining that when they purchase it, they thought, or it was represented that they have a good view. Yung pala, a year after, 2 years after, there's another tower, tower 1, tower 2 being constructed on top of, in front of their unit, blocking their view. So for cluster development, wherein there will be several towers or condominium buildings, they have to disclose the other buildings to be erected in the project area. Even in the way you express the location and distance, it has to be, you should not be misleading. You should not tend to mislead the public or prospective buyers of its proximity, accessibility, and value. Like for example, you don't express it in terms of number of hours from Metro Manila or from Quezon City or from a particular place, but in terms of kilometers. Kasi we are a lot of advertisement, they would say 20 minutes from Metro Manila. Yung pala, their point of reference is the last town or the last city in Metro Manila, somewhere in Cavite. Yeah, but it's like it's in Cavite, the point of reference is already Las Piñas or Parañaque. So that is not acceptable. It should be expressed in terms of kilometers from a known place or landmark. Okay, there are prohibited statements. I was saying, even if you are just making an announcement, even without yet a license to sell for the project, there are prohibitions. Of course, these are intended to prevent selling. You cannot provide office address, contact information, because that is the only reason why the buyer would contact you is for sale. So that is prohibited. Although theoretically, it's so easy to circumvent that you can just Google the developer's name, developer's office, you will find the contact information. So, but just the same in our rules, no office address, no contact information, who are the brokers or salespersons are not authorized to be included in an announcement, and any other information or statement conveying or suggesting selling or marketing, like a few units left, something like that. So those are indicative of selling already, or suggesting selling already. And this is important. Sometimes they do announcement materials in flyers, brochures. It's perfectly in accordance with our rules, but they will staple, insert, or attach the prohibited material. So that is not allowed by indirect incorporation. You insert a piece of paper, you staple, attach, or you make a stamp mark of the prohibited statements. That is not allowed. And any violation is equivalent to selling without license to sell, which, as I have mentioned, the imposable penalty is, based on our current schedule of fines and penalties, 10,000 per saleable lot or saleable unit. So if you multiply 10,000, if let's say it's a condominium with 200 units, that's 10,000 times 200 units. That's how we compute the violation for selling without license. Okay, in an advertisement, you cannot, we will not, of course, it's subject to prior approval. We would eliminate this, but sometimes our approved material does not get, then what gets printed is different from what is the approved material. So these are not allowed. Disclaimers like saying, like for example, design standards subject to change, the time of completion and delivery of plots or units subject to change, those are not allowed. And then you cannot include future project. If you're advertising what you're doing now, what a certain project which is already licensed, you cannot include a future project which is not yet licensed, except what I was saying, cluster development. If there would be towers 2, towers 3, you will have to disclose that. And of course, or misleading information either by text, illustration, or pictures are not allowed to be included in an advertisement material. Okay, ito po yung importante na we will always look for, and you notice particularly if you see billboards, advertising projects, these are the required information: the name of the developer, the license to sell number, the advertisement approval number, the project completion date. That is important because a lot of buyers, they get to be misled that akala nila in a year or two tapos na yung project, yung pala it would take 5 years, 6 years. So the project completion date is mandatory in the advertisement material. The advertisement must disclose the exact location of the project, including the street name, and if applicable, if there's a maximum selling price, that's for socialized and economic housing, the maximum selling price must be indicated in the advertisement material. These are also important, like for example, the license to sell, a lot of developers are complying, but they would just have it printed in a very small, almost fine print, yung license to sell number. We don't know why developers would want to hide the license to sell number, where in fact, it gives legitimacy, and it's a disclosure to the public that it has been approved, the design and standard has been approved by the department. So we do not know why they want to conceal the license to sell number. And so our rule provides that your license to sell number, the font and size must be the same with the contact information. On the name of if your telephone number, email address is this big, the license to sell should be of the same font size. There is a prohibition against fine print and verbal fine print for those in broadcast advertisement. Bawal po yung boses na ang bilis-bilis and you hardly understand. That's verbal fine print that's prohibited in broadcast advertisement of projects. You have that the material must disclose the advertisement approval number so we can readily identify whether a project is approved or not, or advertisement is approved or not by our regional offices. The project completion date is mandatory. Okay. Nagkadoble po tayo. So these are the mandatory requirements what should be stated in the advertisement materials. So I guess I went briefly with all of this, but again, due to time constraint, but I will be very happy and I welcome if we can have another opportunity for a more exhaustive discussion on our rules on brokers and salespersons. Yun lamang po. Maraming salamat po. Thank you po.
Maraming salamat, Attorney Aguila. Talaga pong with your presentation, it was very clear that you are really one of our partners in the professionalism of our industry, the real estate.
Salamat po. Yes, thank you.
It's really an honor to be with you today, and definitely po, PRBRES will arrange a second part 2 po para I think due to press time, marami pong questions, especially on the practitioner side and the developer side. I think this early, can we present can we show the plaque of appreciation that we are presenting to our dear Attorney Angelito before we proceed to the Q&A? Okay. The certificate reads, the Professional Regulatory Board Participation. So here, Attorney Angelo F. Aguila, Officer in charge of the Housing and Real Estate Development and Regulation Bureau of the Department of Human Settlements and Urban Development, for having served as our guest of honor and speaker on this fourth virtual real estate awareness program, given this 30th of October, in the year of our Lord 2020, signed Honorable Pilar Torres Banaag, Rafael Pajardo, Honorable Jose Arnold Tan, and our Madam Chair, Ofelia Carbonell Binag. Thank you so much, Attorney. At talaga pong isang karangalan na kasama naman kayo. And this will be delivered to you with our token of appreciation. In charge po dyan si Opel dahil kayo nyo. Okay, I'd like to turn you over to Honorable Pilar Torres Banag to handle the moderator. BM Pilar. For the Q&A. Naka-mute ka, BM Pilar?
Again, good morning, Attorney Aguila, Chair Ophel, BM Paeng,
Yes.
our colleagues. And
Good
we have
morning
here,
po.
morning again, we have here questions addressed to you. Although you had answered several questions, but I'd like to raise few among the many questions that was brought to our attention. This question goes, what shall we do if we see advertisements at Facebook, SMS, and other mode of advertisements? Can we report it with the DHSUD? Is there standard report form that are required from the one who will report the violation?
Yes, ma'am. Those are violations. We can impose sanctions, but we need evidence. What we have been telling brokers and salespersons, particularly those who are licensed and accredited, you come up with a screenshot. And then if we can identify who posted that evidence-wise or evidence-based, our regional office can try to locate them, send them a notice of violation, and impose sanctions. If not, we can if we cannot enforce the imposition of sanctions, we can post on our website those brokers or salespersons which are not complying with our rules. So at least that is already a sanction on them, and the public will be aware of who are these unscrupulous practitioners, or if we can call them practitioners. There is no particular requirement on how you can submit that. Just submit it to our bureau or to our regional offices, and all our regional offices have monitoring division. They go out, and then they have legal offices also, which can impose sanctions. So just submit to us any evidence, like a screenshots or that would prove that these brokers or salespersons are engaging in illegal practice or coming up with advertisements which are not approved or which are not compliant with our rules, and we will try to locate them and impose sanctions on them.
Thank you for that, sir. Next question po. We heard that the DHSUD, formerly HLURB, had task force who did monitoring on compliance of PD 957, specifically on advertisements. Is that task force still active? Who comprises the task force? Can it be possible that the DHSUD and PRC-PRBRES create a task force to run after the illegal practitioners and violators of PD 957?
Yes, ma'am. As a matter of fact, in one of our recent MANCOM meetings and pre-MANCOMs, that became one of our important agenda item. We want to reactivate the the task force, they call it Task Force PD 957, particularly against illegal advertisements, illegal subdivision. So, and we are, because there are a lot of complaints lately that can be reactivated, and our secretary specifically instructed that we reactivate that. And then, as a matter of fact, I raised in our last MANCOM that the possibility of the department and the PRBRES, our regional offices, to come up with a joint effort or campaign in enforcing this. Magtutulungan po tayo with our licensed brokers and salespersons, accredited salespersons. And the secretary is very much interested in doing that kasi nga po marami na po talagang mga complaints on unlicensed subdivisions, unlicensed selling, unaccredited salespersons, and unlicensed brokers engaged in this practice. Kawawa po naman po yung mga licensed brokers natin tsaka mga accredited salesperson, and they really work hard. Marami ng mga hindi naman po mga lisensyado nagbebenta rin po. We are really keen on activating that. We have to come up with a joint effort on this, ma'am. Tulungan po tayo.
Thank you so much. Thank you so much, sir. That is a very good development as far as our quest when it comes to protecting also our legitimate practitioners. There's another question, Attorney Aguila.
And also, ma'am, yes, ma'am, if I may add, we can go a little even further than that because we are instructed to seek assistance from our partners with the NBI, DOJ for the filing of cases, and then PNP also. There are our partners in going against squatting syndicates, and we are going to engage them to be our partners in going against this unlicensed practice of unlicensed real estate service practice. Is that tama po ba yun? Unlicensed practice, yes.
So magandang development po yan, and that's why in this particular awareness deserves already a warning to the colorum or the illegal practitioners and even our professionals who have been violating as far as the provisions of PD 957 and corollary to that, even violations of RA 9646. Another question, Attorney Aguila. Can the SUD help the real estate brokers and salespersons pertaining to their unclaimed commission or professional fees of which developers are paying the earned commission or professional fee on installment payment? Ibig po sabihin dito, meron po silang problema sa collection ng kanilang professional fee. Instead na ibibigay kaagad ng developer, ang ginagawa ho installment payment. So pwede ho bang makatulong si DSUD dito sa problemang ito?
Yes, ma'am. Ganito po yan. Before, with the HLURB, it had a limited jurisdiction. Ang nakalagay lang po sa batas, cases filed by buyers against developers. So yung pong mga kaso ng brokers against developers, sa regular courts daw po dapat isampa yun, i-file. But now, although this is still untested, under the new department, under RA 11201, there's another agency created, the Human Settlements Adjudication Commission, which is an attached agency of the department. It has an expanded mandate. Nakalagay po doon in general, all issues and disputes in the implementation of the mandates of the department. So as a matter of fact, when we were crafting the IRR, we focus on that. Our counterpart with the we call it the HSAC, Human Settlement Adjudication Commissions, they're saying that we have an expanded mandate. Na if it's not allowed under the old law, it may be allowed now. So ang sinasabi po namin, baka po merong gusto mag-test ng jurisdiction, mag-file po ng case and let the HSAC assume jurisdiction or decline the assumption of jurisdiction. Let's see. But ang sinasabi po nila, they have an expanded mandate now. Sana po kasi po, understandably, mas mahirap magsampa ng kaso sa korte, mas matagal. Hopefully with the new HSUD, we can easily assist the brokers.
Sige po, at least klaro po yan sa mga professionals natin na nahihirapan po mangolekta ng kanilang komisyon. So this time, meron silang
Subukan po
pag-asa
nila.
that it can, yes, they can file pala cases doon sa ating adjudication
Subukan,
commission.
they can try that.
Ayun, malinaw yon mga kasama natin, mga colleagues natin, malinaw yon. Pag may problema kayo, pagdating nyo doon sa installment payment ng inyong komisyon kasi hindi kayo nababayaran, you can go now and you have an avenue where to go, and that is as far as the adjudication commission ng DSUD natin. Another tanong po, Attorney Aguila. In case of controversies between the developers and the brokers, can they file the case at DSUD? In what particular bureau shall they go?
Yan po ang baka, if they file a case with us, we might directly endorse that to HSAC. Kasi po, all the cases are there. Although we do conciliation, sa akin po, let's try. Kasi this is the first time with under our new mandate. All regional offices have a conciliation. They have lawyers to do conciliation. They can file an initial complaint or letter complaint with our regions and see. I am not speaking on behalf of them. They can assume jurisdiction and try to come up with conciliation. If the parties fail to arrive at any settlement, it can be endorsed to the Human Settlements Adjudication Commission. So what I'm saying is these are new avenues for us under the new law.
Okay, that's great, Attorney Avila. So at least yung mga kasama natin, alam nila na meron talaga. Ano po say, Ray, sent to our email, ito po yung tanong, are practitioners who don't do project selling, again, are practitioners who don't do project selling required to get HLURB or DSUD accreditation? Or if they had before and stopped the renewal of their accreditation, are they required to pay penalty when they renew? Again po, our practitioners, yes po, yung sinasabi po niya dito, kung hindi ako nagpa-project selling, kailangan ba ako magpa-accredita sa DSUD? Kung halimbawa po, meron akong accreditation, hininto ko po yung accreditation, meron po bang kakaibat na penalty kung hindi siya magre-renew o kaya magre-renew siya ngayon ng kanyang accreditation?
Okay. If the practitioner is permanently not engaged, talagang hindi po siya engaged in project selling, there is no need to register and no need for the annual renewal of registration. But if you once registered with us because you were engaged at one point in time in project selling, ang nangyayari po in those years na he can easily claim that he did not engage anymore. He did not practice anymore, and then after 3 or 4 years he started to resume project selling again and would like to renew. Meron po kaming additional parang ang charges for failure to register po. Minimal lang po naman po 'yon. But you'll have to pay for those years na kasi it's easy to say na hindi po ako nag-practice. But for us, that is failure to renew your registration. Pero minimal po ang charges namin. Kasi the requirement is parang mahirap po kasi sabihin for that year hindi po ako nag-practice kasi project selling it happen the opportunity is there every now and then so mahirap po sabihin hindi ako nag-practice.
Okay, so very clear po 'yon. Pag wala ka sa project selling, hindi mo kailangan magpa-credit at saka kung meron kang accreditation, hindi ka nag-renew, kailangan mo magbayad ng penalty. Although sinasabi ni Attorney Aguila minimal lang. Okay, may penalty pa rin. Okay. Another question, Attorney Aguila, this is practically from a broker. How can we, broker, help our buyer if the developer failed to turn over the project on the promised date more than 2 years, close open parenthesis. Buyer had been fully paid and the broker fee was not released until the turnover. Ang tanong ho dito, tapos na po yung hindi na turnover o kaya yung developer failed to turn over the project as promised, which is practically within 2 years, which is the development permit. More than 2 years na ho yata ang lumipas, hindi pa rin turn over. Bayad na po yung seller, yung buyer doon sa developer. At saka sabi ng broker, until now, hindi pa nare-release yung kanyang professional fee kasi daw ang sabi ni developer until turnover.
Yes, ma'am. Hatiin po natin yung question. In behalf of the buyer, our rules are clear. The developer is bound under PD 957 to deliver the unit, to deliver the title upon full payment or as promised based on the approved plan or as advertised kung kailan niya pinangako. Otherwise, that buyer can demand rescission, refund with interest and penalty and charges. On the part of the broker, that's the one I was saying, with expanded mandate of the department and the HSAC, ako nga po personally, I would encourage them to test it if the HSAC would assume jurisdiction. I think baka po it sounds okay with them. Baka po on the part of the broker in the enforcement of their rights under their agreement with the developer, that can be enforced with the HSAC. Yun po yung sabi that might be enforceable with the HSAC. That's what we can test now under the expanded mandate of the new department and the new Human Settlements Adjudication Commission. But for the buyers, malinaw po yun ng mga karapatan ng buyers. They can go to our regional offices for the conciliation and mediation, or they can in fact directly file a case also in HSAC. Ganun po.
Thank you. Thank you po. Because of time constraints, I will be raising the last question. Ito po yung last na question. Some marketing arms of the developers coddled agent without PRC license and accreditation in the case of salesperson. They did not give ID card. Their managers are neither licensed. They are into project selling. Under the SUD, are they covered existing law? And how will the SUD deal this matter?
When it comes to the developers engaging unlicensed brokers, medyo nahihirapan po kami because our jurisdiction, our authority based on PD 957 is on the project and on brokers and salespersons. The projects are the one registered with us, licensed with us. The brokers are the one. But the developers, wala po kaming sanctions na imposable on them because we regulate the projects, not the developers. What we only require in the registration of developers, as if they are the one engaging their own brokers, we require them to register also with us. If they are complying with engaging licensed brokers only, and 20 salespersons per broker, per licensed broker. We try to compute that. We account for that also in compliance with the RESA requirement. But sometimes we cannot impose any sanction on developer na nag-engage po by not employing them directly, engaging the services of unlicensed brokers. Pero baka po yan din po yung mga sinasabi nating under our new mandates. Maganda po yung mag-file sila ng formal letter complaint so we can resolve that. Para kasi I am personally I cannot decide on that. I have to make a recommendation on what should be the stand of the department considering our new mandates on these issues. Maganda pong i-bring up yan formally.
Yes po. At alam ko rin po, when we look at the accreditations and registrations, you have a specific resolution issued by the SLURB before, way back April
Yes.
15, 2015. And this is actually registration at HLURB as a licensed broker and accredited salesperson under RA 9646. And for the information of our colleagues, we had initially discussed with Attorney Aguila on possibility of coming out with a coordinated effort and as well as revisiting the resolutions that they had issued on the implementation of PD 957, particularly Resolution 922, where we also air out our concern for those who made publications, who made representation to the SUD, and they are not licensed real estate broker and accredited salesperson. For the one who asked this question, broker Hieronimo, rest assured that the board and the HLURB will be addressing all your concerns as you raise it to us. And for that, thank you, Attorney Aguila, and I would like to give to the floor now to our MC, Honorable Rafael Fajardo.
Maraming
Thank you,
salamat
PM
po.
Pilar.
Maraming salamat.
And thank you, our dear Attorney Aguila, our very able partner in our profession. Maraming salamat po, and definitely magkakaroon po tayo ng part 2 dahil marami pang questions na nakalinya doon kay BM Pilar na hindi pa nabasa. And again, maraming salamat po, and for our closing remark, I'd like to turn you over to our dear Madam Chairperson, Honorable Ofelia Carbonell Binat. Nakamute ka, Chair. Chair. Nakamute.
Chair, nakamute ka.
Sorry. Thank you so much, BM Paeng, and to my board members, BM Pilar and BM Arnie. Thank you so much, Attorney Aguila. This episode has been very, very informative, and we learned a lot of updates from the DHSUD. Also to our brokers, our colleagues. Yan, marami tayong natutunan. I know there are more questions, concerns lingering in your minds, but because we don't have enough time, so sabi nga, we will have another episode. Siguro papayag naman ulit ang DHSUD kasi sangkatutak ang dami pang dumarating na mga questions. Yun nga pala, hinihingi nila yung how will they, where will they, saan daw nila ipapadala yung questions, complaints para sa DHSUD. And sa ating mga colleagues, mga practitioners, we hope that you will join us again. What do you think, members? Next week or every other week tayo?
Next episode.
Next episode tayo next week. So,
We'll announce.
maraming hindi nakapag-live stream kasi nasa 100 lang tayo dito sa Zoom. Pero rest assured, i-replay po namin itong recording na ito sa YouTube. So, yes, ipapa-YouTube natin ito para yung iba ma-reach out din natin. And then, I'm sure, puputaktihin po tayo ng mga questions. Marami po tayong questions and concerns, Attorney. So magiging suki ka na namin, Attorney. Don't worry. So with that, I say thank you again. God bless everyone.
God bless. Thank you.
Thank you.
Madam
Thank you,
Chair,
everyone.
Attorney Aguila. God bless you.
Thank you, Attorney
Thank you po.
Aguila.
And dear board and our viewers, thank you and see you next episode. God bless us all.
Thank you, Noemi.
Always.